Welcome to the Leadership in Law podcast with host Marilyn Jenkins. Cut through the noise, get actionable insights and inspiring stories delivered straight to your ears. Your ultimate podcast for navigating the ever-changing world of law firm ownership. In each episode, we dive deep into the critical topics that matter most to you, from unlocking explosive growth to building a thriving team. We connect you with successful firm leaders and industry experts who share their proven strategies and hard-won wisdom. So, whether you're a seasoned leader or just starting your journey as a law firm owner, the Leadership in Law podcast is here to equip you with the knowledge and tools you need to build a successful and fulfilling legal practice.
Welcome to another episode of the Leadership in Law podcast. I'm your host, Marilyn Jenkins. Please join me in welcoming my guest, Dan Scola, to the show today. Dan is the managing partner of Hoffman Baron LLP and also manages the chemical, pharmaceutical, biochemical, and medical device practice group in the New Jersey office. He has extensive experience in polymers, pharmaceuticals, and medical devices. He also has vast proficiency in obtaining protection for software-related inventions. He specializes in building IP portfolios and designing strategies to protect and enhance company value. He also practices extensively in post-grant proceedings at the USPTO and has argued post-grant proceedings at the appellate level before the CAFC. Prior to earning his law degree, Scola was a chemist with a particular experience in material science, including polymers, adhesives, biodegradable approaches to material science, and engineering. He was a scientist at Pratt & Whitney Division of United Technologies. I'm excited to have him here, Dan. This is exciting.
Oh, thanks for having me. Thank you, Marilyn. Appreciate it.
Absolutely. So, okay, having a scientist going to becoming an attorney. I love it. Let's hear the journey.
Well, it began, I've always had an interest in science, but also there's also been a very creative aspect to my personality. And there's a really important interplay between science and creativity and, the ideas that come out of science and some of the more creative inventions have come out of, just being able to take ideas and put them in tangible form through the scientific mediums. And, all these ideas should be protected in some way because they're all important and they all end up being, we create ideas every day and we create intellectual property, which most people don't think about. Ideas are assets in a sense. And
That's right.
when you reduce them to something that can be a product or a process or something that can be productive for society, it is a protectable asset. And it serves as an engine for this, economy. So I'm interested in it largely because, my father was a scientist. And he was quite creative, and he took his ideas before he had protected them to a manufacturing company. And I saw that the manufacturing company stole some of his notebooks, which ended up being in products they made. And it was one of the first modular, marble-like polyester, modular bathroom facilities like sinks and things like that. That was very early on, before they made any of these. And he had these formulas that worked extremely well there. I know I did the testing for him as his technician, so to speak, and he couldn't protect them. And he didn't have the wherewithal. He didn't have the money. He had the interest, but he just lost that. And those were among many ideas that he had. And that spurred me on to thinking, well, there's got to be a way to do this. So that's where my interest initially began in IP. Quite early on. And it was not a sexy area to go into. People thought back then that intellectual property, they thought of sort of the warmed over engineer with the pocket protector walking around with eye shades on, bumping into walls, sort of not.
And the sleep protectors.
Exactly. So it wasn't an area of law that was, at the forefront. And of course, as technology developed, it became so.
And he probably, I'm sure many inventors followed in his steps just by having that happen to them, not knowing to protect their ideas before actually going to a manufacturer. So I'm glad that you were able to, protect other people in the future from that.
Yeah, that's how it's. Well, I have this saying that it's a bit catchy, I think, but you tell me. It says, you have to tell to sell. In other words, you have to tell people something to sell it, but you have to protect it to collect. So it's tell to sell, protect to collect. And it's really true. Most people are so excited about their ideas that they go out and they tell everybody. And it works against them if they don't have protection. In most countries, once you've disclosed it, it's in the public domain and you can't really get back your IP, especially in the patent area. So it's, you got to protect it first. And it's a chicken and egg thing. I know people sort of say, well, I don't have the money to protect it, so I'm telling someone so they can give me the money. There are ways around it, obviously, but that's one of the biggest things people go wrong when they're disclosing their ideas before they protect it.
I see. Yeah, and it's so interesting. I was in an inventors class years and years ago, and that was one of the things that were, you keep your notebooks, you do all of this stuff, but for patent pending was one of the things that made it a bit more affordable to at least get the process started.
True. Yeah, it's very true. Well, I always, wonder where people are going to get their money, but I do tell them, look, you need to find someone who believes in you and then your ideas to give you enough money to get started, because otherwise, people want some certainty. So an investor wants a certain amount of uncertainty if he's going to invest in an idea. He wants to know, well, yeah, I know it's valuable, but how is it going to be protectable to me? How am I going to be able to capitalize and get my money back? And if you have some sort of protection on it, that gives them a certain amount of certainty, some security. In fact, many of them take security interests in the patents, when they get their money. And they have, they make those of record. And so if someone goes to try to buy it or infringe it, they have rights to it. So.
Well, I've watched enough, Dragon's Den and Shark Tank, and that seems to be one of the questions that comes up on products is, do you have a patent?
And it's very true. It's funny because there's, people think that they get confused about what patents might really cover and what they're about. And they're really they're nationally based. So every country has its own. I mean, they only go as far as the boundaries of that country. So the U.S. patents only cover U.S. And, there are different kinds of patents. And sometimes people say, well, I have a patent, so I don't have to worry. I can do whatever I want. And that's not really true. Patents cover what you have. They're a boundary around what you own, but they don't allow you to walk anywhere you want because other people have other boundaries. And you could, it's almost like, well, I have a piece of land. If you think of it in the real estate analogy, it's pretty easy. If I have a fence around my piece of land, and that's my patent, basically, that piece of land, I can walk anywhere in that piece of land because it's my patent. But if I go outside my patent and I run into someone else's piece of land, I can't just walk there because they have the patent on that. So you have to understand what a patent covers. And the U.S. law, and most countries follow this, allows you to get another piece of land within a bigger piece of land. So if you have an improvement on an idea, for example, you can't use your improvement because it falls within the larger piece of land. So someone might have this, and you have, well, I found a better way to do that. It's this. And you can't use that, but everyone around that piece can use that bigger, whoever is licensed for that larger piece gets to use that, but not the piece that's the improvement, vice versa. So you end up cross-licensing in a situation like that. So but it's just that there's a basic, I think, lack of understanding. And if people understand what patents and trademarks and copyrights are, they realize that it's everywhere. It affects everything they do. Every time you touch a product, it's got one of those IP things connected to it somehow. It's really true.
Wow. And of course, with more and more things coming out, and there's, like you said, there's ideas every day. Wasn't there an antidote that in 1851 the USPTO said nothing would ever be invented again?
Yeah, everything is old, and it's funny because it's true that everything is a combination almost of things that have been invented before. But that's what spurs things on, and that's why the law has developed with protecting improvements and trying to get the engine of innovation going by giving you certain rights that allow you it's a limited monopoly. It's patents not good forever. What is really good though, trademarks are renewable as long as you're using them. That's very, very powerful. And copyrights go, now they go for the life of the copyright to first, not inventor, but the copyright owner, the life of that plus, 70 years. So that's a pretty long time. So you can guess what Disney does. Disney, for example, they like copyrights and they like trademarks. They can keep renewing the trademarks as long as you're using them, and the copyrights go for a very long time. So that's the original, I believe the original copyright on Mickey Mouse is just recently.
Yeah, I think it was the Steamboat Willie character because he transformed into Mickey Mouse or something like that.
The original Steamboat. Yeah, exactly. Yeah.
That had to be disastrous because they couldn't do anything about losing that.
You can't do much about it. No, it is. Yeah.
Wow.
Yep.
So in part of your bio, you said that you help build IP portfolios and design strategies to protect and enhance company value. I'm very intrigued. Can you expand on that? How do you help do that?
Yeah, sure. Well, if I take the easiest way to explain it, I'll take the sort of the startup company, because that's where I feel I can give tremendous amount of value, because they know very little, almost nothing about the IP usually. They just know they've got this great idea. I want to take it to market and develop it. So one of the things you need to do is that, like you said, there's got to be a strategy involved, because you need to know what has been done before. You need to position, let's say it's a patent area, okay? So it's an invention. You need to position that invention, find out what the invention is. Okay, what is the invention? You speak to the research people, and they're, one of the things I realize is you don't have to be the smartest person in the room. It's better to get smarter people around you and ask questions, and they will teach you. So most of the time I deal with very bright people, and that's a lot of fun because you learn so much, and usually they're very willing to tell you what they know. And then you can position the invention, you can understand the invention, and it's a nice, back and forth repertoire, back and forth, a repartee back and forth. And you then take that invention as you reduce it to words. They call them claims in the patent sense. It's claims. I claim, and you write down, you try to describe the invention in words, not easily done many times. And then you have to take that and position it against what has been done in the past, anything that's been done in that area in the past. So you have to know that sort of the landscape of that particular area of technology. If it's a pharmaceutical area, it could be a pharmaceutical drug you're trying to get it against. If it's a mechanical or medical device area, let's say you look at all of the vascular grafts or all of the different types of hypodermic needles or whatever the particular invention is. And you say, well, the differences in what the invention is and what has been done before is not an obvious leap in science. It's a change that would not have occurred but for this inventor. So you have to make that argument to the patent office, and they don't always buy it. And that's the job of the attorney to convince the patent examiners that in fact there's an invention that should be protected. So you then build a series of patent applications that hopefully get prosecuted into patents. And you've got to be careful how you build it and the timing, because you could set up barriers to yourself. Because every time something publishes, it then becomes in the public domain for use against other inventions. So you compare it to what's in the public domain. Well, that's the same as my invention. I'm not going to get that as a patent because it's the same. So you can't, if it's been done before or something that's obviously, in view of what's done before, you can't get a patent. So it's building those sorts of things and recognizing the best. It's a lot of creativity is what it amounts to. How you create a nice pathway from A to B where there's lots of landmines and pitfalls with other people doing similar things. So you have to sort of negotiate way through it and say, I think we can get coverage on this area, but not this area, or this area and not that area. So, and you build that whole series of, it's like a thicket, a fence, or an area where there's a bunch of landmines you have to walk around. Those are you put those patents in those areas so people can't just do whatever they want. They say, well, I love this idea, let's do it, and they run into your patent. It covers that particular, thing they want to do. So that's a long way of saying it, but
well, that's excellent. I like the way you're talking about spacing it out so that you're correct. You are protected for the long term. Mm-hmm. And so all those are sellable assets, obviously, when you're ready to sell the business, or you can sell patent itself.
Yeah, they're certainly they're considered, intangibles, but they're assets that could be sold. You assign the rights to them, and you can sell them. And then if you have the rights to them, anything that's made under it also comes. So it could be products that are made under the rights. But yeah, in fact, portfolios sometimes are what allow, IP portfolios are what allow people to go public. I've been involved with many startups which have gone public based on the fact they have a big portfolio that we've been able to develop. Now they have some products too, of course, because no one wants to buy a company that doesn't make anything, they didn't make any money at all. But they have to have some sort of assets, IP, in the background.
Are you a woman attorney running your own firm but feeling like you're on a never-ending treadmill? This podcast is sponsored by Wealthy Woman Lawyer, the business coaching company that's helped hundreds of women lawyers over the past 12 years, just like you, transform revenue-draining practices into wealth-generating machines. Their clients, including Brittany and Gianni, routinely break the seven-figure barrier while working fewer hours. The difference? A systematic approach that builds a firm that works for you, not the other way around. Ready for a practice that funds your dream lifestyle and gives you time to enjoy it? Visit wealthywomanlawyer.com today.
Now, in thinking of that term, what about apps? Is that something that's
absolutely? We have a number of clients that we've done apps for, and that those are also very protectable. Because they involve computer science, and they have to have some kind of an algorithm based. Math itself is not protectable, but how you use the math in combination with other mechanical things or tangible things. So a software system, for example. So I have a client that, for example, they build these large communities, and they plan these communities. And when you want to go and live in one of these communities, it's like a little city. So it has everything. It has a movie theater, it has banks, but it's a well-defined area, thousands of acres, but houses. And you want a certain house with a certain color, certain types of appliances, facing a certain way, and you want to know if you can buy that house, and if you can, you'll buy it today. Well, in real time, there wasn't a way of doing this, because the builders would be doing things in one part of the community, and then someone else would be at the same time saying, I want something very similar across the street, and they don't want cookie cutter looking communities. So there wasn't a way of saying, well, how do we get it so that this community does not look like in the 40s and 50s when they came back from the war, they just built, rows of houses and they were all the same. That's not what people want anymore. So they came up with a way, an algorithm of which they built into a computer app, which allows anyone to request what they would like at that time, and it will tell you if it's available. And anyone can farm. So out of thousands of homes, whether I can have a red roof, and maybe I can't because there's a red roof across the street, and they don't want an monopoly type of algorithm.
No one
monopoly.
Front door.
Monotony.
Right.
Okay. Not anti-monotony.
I love that. And that's so creative because, some of these developments are just massive.
Yeah, they are. Yeah.
Being able to drive through them and not go, this is a development is what we used to call in the 80s.
Yeah,
So we're boxes, right?
Yeah, exactly. Yeah. Yeah. So apps can be done. There's very few things that cannot be put into some sort of IP asset. Straight math, for example. Okay. No, you can't. The statute defines these things, gravity. No, things that natural, things that exist cannot be, nature can't be part of, because it's a limited monopoly. You can't monopolize something that is already in the public domain.
And you can't, I'm sure that AI falls into that as well. That's not something that you could go and put a patent on.
It's not. Yeah. The problem right now is people don't know what AI is. Everybody has their own definition, and they're trying to get their hands around how do you actually police AI in any meaningful way. The Patent Office of the United States has said that AI is not a person, and only people are entitled to patents. So that's a good step because I think AI could file a patent every 30 seconds if it wanted to. You think about it. So it's good that AI itself can't be. Now you can get patents that use AI as part of the invention, but AI is not the inventor. It's the inventor, people or person does the invention. Yeah.
Well, we were having a conversation, I think, last week about how you also can't trademark an AI product or something that was written or created with AI because it's based on so much test data and it's reading all of these source materials that you can't say that it was yours.
Yeah, that's true. I mean, it's the one thing I always caution my staff, my attorneys about is the use of AI in the public way. Because if you put someone's idea, which is confidential, when they come to you with ideas as the patent attorney, it's confidential until you end up filing at the patent office. I mean, you don't want someone to steal that. So you don't put it into a GPT chat machine and it becomes into the whole public arena. That is not a good idea. That would be, in my view, a violation of not just confidentiality, but the attorney ethics code. So you got to be careful. I mean, AI is very hyped up, and there's a place for AI, but I don't see it as being, everyone, if you put AI next to a product right now, people think it's like brand new. Machine learning has been around long. It's just, when they first came out with ways to translate your voice into words, the machine learning. All they're doing, they're teaching the machine when you hear this sound, this is what you write, and you do it over and over and over again. The machine just finally gets it right. Now it's pretty good.
Well, remember all the hype when the first remote for a TV came out that you could speak to the remote and it would do. That was like, oh my God, that happens.
Yeah, I know. Well, a lot of this stuff is it's not as new as everyone says it is. I think it's been around a long time. I see lots of ideas in my business, all the time. And when I was inside counsel, I used all the ideas that people would send into the company would come through me. And I have to say there were not many good ideas that came in. There were lots of crazy ideas because it was a pharmaceutical company. But occasionally there was a good idea. And, if that idea could be championed up through the marketing people and the marketing people then could talk to the business people. And, every once in a while they would take an idea and they would say, yeah, let's have this person come in and let's speak to them about what their business plan is and so forth. But it wasn't very common. It was the not invented here syndrome for most of these large companies.
Interesting.
Changing now, I think, but yeah.
Yeah. When you say about taking your ideas, that someone brings you an idea and you have to be careful not to put it in ChatGPT or anything like that because you need to protect it until it's filed. The one thing that I saw about 6 months ago, and I turned it off on mine, is Microsoft Word did an upgrade that there's a check mark that's default that you're allowing all of your documents to be used in a large language model training.
Crazy.
And I was surprised that it was turned on by default. You had to go in and
yeah. See, I don't like that. That's just not I don't even care if you give notice. That should not be an option.
No, I agree. I mean, many authors write their books in Word.
Yeah.
Where else are you hiding for the most part? But
The whole copyright area, I think, is going to be thrown on its head because of this whole AI stuff. And people, did you write it? Oh, well, let's do a search to see if anyone wrote those exact words. Well, if you wrote those exact words, but they were your own origin, and it's possible, you're entitled to copyright them. As long as you're not stealing it. If you're not stealing it, it's not a violation of copyright.
well, the same string of words could mean, it's.
I mean, I'm not even talking about paraphrasing. I mean, yeah, I agree. You can say things in 100 different ways and they mean the same thing. But if you're not copying it and you're coming up like I was not in law school when this happened, but when George Harrison was accused of copying, My Sweet Lord from, a song that he had heard, and he lost that case, he lost it, I forget who it was that sued him for copyright infringement. But I thought that was a terrible decision because he had he listened to the song? Yes, a few times, but it wasn't like, I didn't think there was enough evidence to show that he was so influenced by it that he was borrowing it. Now the law has developed where you can borrow a little bit. It's really a question, how much did you borrow to create what you created? Because if we talk before, I mean, is there a series of words that have never been put together in the English language? I don't know.
I don't know.
It wouldn't know that. So
That's interesting. I mean, I read a statistic one time that the Sunday edition of the New York Times has a maximum of 600 words in it. Now, this was back in the 90s because it's written at a certain grade level. So to have your article in the Sunday paper, it can't be using Wall Street Journal words.
really, I didn't know that.
So I found that was quite interesting. But this has been really exciting. And I love hearing your stories and the differences. And I think everyone's going to pick something up about in this episode. It's been a pleasure to chat with you, Dan.
Yeah.
If anybody wants to reach out to you and connect with you, where's the best place for them to do that?
Well, they can certainly look at the the website. It's the Hoffman and Baron website. It's hoffmanandbaron.com or hbiplaw.com, and or they could just find the phone number there as well. But that's probably the easiest way. Just go to the website. Yeah.
Excellent. We'll make sure that that's in the show notes. And gosh, thank you so much. This has been entertaining and very informative. I appreciate your time.
Yeah, thanks. Same here, Marilyn. Yeah, it was very nice. Appreciate being on.
Thanks for joining me today for this episode. As we wrap up, I'd love for you to do two things. First, subscribe to this podcast so you don't miss an episode. And if you find value here, I'd love it if you would rate it and review it. That really does make a difference in helping other people to discover this podcast. Second, you can connect with me on LinkedIn to keep up with what I'm currently learning and thinking about. And if you're ready to take the next step with a digital strategist to help you grow your law firm, I'd be honored to help you. Just go to lawmarketingzone.com to book a call with me. Stay tuned for our next episode next week. Until then, as always, thanks for listening to Leadership in Law Podcast, and be sure to subscribe wherever you listen to podcasts so you don't miss the next episode.
Thanks for joining us on another episode of the Leadership in Law Podcast. Remember, you're not alone on this journey. There's a whole community of law firm owners out there facing similar challenges and striving for the same success. Head over to our website at lawmarketingzone.com. From there, connect with other listeners, access valuable resources, and stay up to date on the latest episodes. Don't forget to subscribe and leave us a review on your favorite podcast platform. Until next time, keep leading with vision and keep growing your firm.